Mr. Majumdar has serious objection in it. Why?
My lord, because on the last occasion, we are directed to take certain instruction. Then instruction is there.
Only thing is that the second one would
My
come in
Lord,
now.
That's
Hmm?
My lord may take up on 16, my lord.
16 or 17 tours.
Whenever it's convenient.
17 tours.
Ms. S. Chutia, Learned Standing Council, Secondary Education,
Elementary education.
Elementary Education Department prays that she be granted further. Further 10 days time to complete her instructions in the matter. Prayer is not objected to by Mr. S. Bhattakur, Learned Council, for the respondent in review petition number 101/2025 and petition in contempt case number 173/2025. Also, in view of the above, registry to list this matter again on 17.
Deeply obliged.
Right, Mrs. Lordship. Right, Mrs. Lordship. I beg to mention item number 8, Lordship. Lordship, may agenda matter for the day, Lordship.
Wait,
Lordship, the petitioners, petition number 2 has filed RTI for the details of the candidate who has passed the examination, Lordship, in the post of constable in BSF, Lordship.
it is a
File on 21/11,
the
Lordship.
2 marks. You don't have the you're below the cutoff marks, so that's it.
Yes, Lordship. RTI has filed by the petition number 2, Lordship.
On the prayer of the Learned Council for the petition, item number 8, registry to list this matter again on 11/12/2025.
Must oblige.
Heard the Learned Council for the parties at length. Hearing concluded, a judgment reserved. Yes, Mr.
Our plea is that, my lord, I was recommended in a sanctioned vacant post.
Got it. Now show me what is the error in the SLC decision. Because if there is an error, then only 18/9/2024 would come into being.
Error means, my lord, due to want of vacancy.
That's it. You show me that what is the error, because they are considering things at a greater level, broader level. So if I have to bring in 18/9 and the coordinate bench judgment in your favor, I'll have to interfere with this. I cannot in air say that the judgment will also, because that are judge cases wherein SLC had not considered. By that time, your 18/9 had come in, asking no further consideration. In that context, the Supreme Court said, the coordinate bench passed that order on a concession by the.
Even they're saying that those are pendants, those are.
And in your present proceeding, we don't have a challenge to that 18/9 also.
Because my case is also pending since 2022.
No, your case is pending because you challenged the SLC minutes. So SLC minutes, because of that order, I cannot set it aside. I'll have to have some basis. Give me that basis.
By the way, I would like to place on division bench judgment that
Yes.
Solita, my lord.
Give me something. Okay, noticed. Anything more?
No, my lord, earlier post was a sanctioned vacant post. So whether SLC can, my lord, reject only saying that vacancy is not available. That's the post on which I was recommended.
No, show me what has happened to that post.
This is the liability of the, my lord, state. that what happened of that post, my lord. I was,
Any statement here that the post is still continuing to be vacant?
my lord, here it is, my lord, itself in the recommendation, it is a sanctioned vacant post, my lord.
Yes, madam.
Lordship, but nowhere it is mentioned that regarding the cadre strength and recommendation of the 5% stipulated quota for compassionate appointment,
Why
Lordship.
did you make?
This
this
is there
comment?
and SLC minutes, Lordship, page 44, Lordship, the concerned page. Serial number 28, Lordship. Lordship may kindly note the cadre strength is 7, shown 7. Vacancy for compassionate appointment shown to be nil, Lordship.
Page.
Page 44, Lordship. It starts from page 40, Lordship. The SLC minutes, Lordship. Page 39 it from. Yeah, Jala.
Where is the DLC recommendation?
My lord, this is page 17, my lord. Operating
Your
code,
name?
page 20. Page 20 in middle, my lord. The Plavan Das recommended for appointment in the grade 4 post. And my lord, kindly see page 22 and excerpt 5. This is a statement showing the candidate for compassionate ground appointment. Plavan Das, sanction letter so and so, so and so.
Where is
Executive-
your statement that the consideration made by the state level committee at page 42, 44 in your case is perverse? Because it says there are only 7 posts. So 0.35, it's not 1. Any statement to that effect, Mr.
In respect of my lord, SLC, my lord.
Hmm.
The SLC recommendation, yes, that was not mentioned, but in DLC recommendation as
No, no.
applicant,
SLC recommendation, they have noticed that you had applied for a post of Khalasi, grade 4.
yes, my lord.
And in that cadre, there are only 7 posts. That is what is reflected here.
Yes, my lord.
Now, whether this is correct or wrong, have you disputed?
Whatever I have found, my lord, regarding this.
No, any
SLC.
dispute to that effect? Okay. Anything more?
My humble submission, my lord, that Devakolita is applicable in my case.
We will consider. Division bench judgment will have to consider.
And
But
the-
Mr.
my lord, one more, whether sanction vacant post can be go away by the state. It is up to the state who has to have the
We
responsibility. to do it.
will consider that also. HR Chaudhary, Learned Council for the petition also had Ms. M. Bhachaji, Learned additional senior government advocate appearing for the state respondent. Hearing completed, registry to list this matter Monday.
Kindly Tuesday.
Monday for delivery for this.
Mine.
Deeply obliged.
Here in this case, my lord, in 3, here, my lord, it is still pending before the SLC. DLC recommended. DLC recommended on 6/2/2023.
Yes, madam, what is this? SLC considered
They did not file affidavit yet, my lord, in this.
Ms.
Lordship.
M. Bhachaji, Learned Council for the petitioner, submits that she be granted a week's time to complete her instruction in the matter. On the next date of listing, Ms. Bhachaji shall apprise this court as to the manner in which the recommendations made in favor of the petitioner, hearing, by the jurisdictional district level committee in its meeting held on 6/2/2023 was further considered by the authorities. Registry to list this matter again on 9. You will be here on 9?
Fine.
9.
9th,
10.
Tuesday, Lordship.
10. Wednesday?
Can it be on 12th, Lordship?
12.
Lordship.
12. Okay, 12.
Fine.
May I please, your lordship. My lord, the outstanding bill of the vehicle requisition, my lord,
Yes.
the respondent number 3, my lord, filed the
Affidavit has been
affidavit, my
filed.
lord, and they admitted that yes, bill he received and forwarded to the deputy commissioner, my lord. And it is pending before the deputy commissioner. Respondent. Respondent 2 is the deputy commissioner.
Well, this is yours, page 34. What is your total claim here?
Here, my lord, 7,85,115 rupees of item number 4.
Hmm?
Item number 4. The amount is not disputed, my lord, as per affidavit. my lord.
No, that is what I'm trying to find out. Where have you said in your petition that this is the amount?
Yes, my lord, I have this paper. My lord, the page 6, the middle portion. Well, the petitioner state that the total outstanding bill of the petitioner's vehicle rupees 7,85,115 rupees only. The petitioner submitted the outstanding bill before the Superintendent of Police, Goalpara, which was received by the office of the Superintendent of Police, Goalpara. Thereafter, the Superintendent of Police, Goalpara forwarded the said bill to the Deputy Commissioner, Goalpara for necessary action. The petitioner on several occasions approached the authority for intimate the payment of the outstanding.
Only
bill.
one vehicle?
Yes, my lord. Here is, my lord, 4 petitioner, they are different vehicle, my lord. Only one vehicle for item number 4 and 5 also, everyone is one vehicle. And
And
different
let us come
occasions, my lord.
to 0649. So the amount admitted here is bills received is around 316,322 and 126. Yes, Ms. Das, bills are admitted. Amounts are admitted.
My lord, paragraph.
Mr. Uddin, page 34, all the petitioners' vehicles are mentioned of the affidavit.
Yes, my lord, what happened in different affidavit I have seen, my lord, the statement they have given, sometimes, you know, the present petitioner's bill in gone in another statement also, my lord.
Okay.
Because the different occasions, the vehicle was requisition. So particularly for one vehicle, they cannot prepare.
My lord, maybe please
lord,
to direct,
If the honorable court observe, my lord.
verify and pay, my
then
lord,
also, my
verify,
lord,
pay will, my lord.
Mr. Uddin, learned counsel for the petitioner. The petitioner also heard Ms. Yudas learn additional senior, learned additional senior government advocate appearing for the state respondents. The petitioner, by way of instituting the present proceedings, has prayed for a direction, for issuance of a direction upon the respondent authorities to pay an amount of rupees 7,85,115, rupees 7,85,115, being the contractual dues receivable by the petitioner in lieu of the requisition of her vehicle for the purpose of law and order duty by the state respondents. Also, as projected in the writ petition, the petitioner in the writ petition has projected that the vehicle of the petitioner was initially requisitioned for a period with effect from 26/9/2019 to 29/2/2020. Thereafter, the vehicle was again requisitioned for a period with effect from 1/3/2020 to 31/7/2020. Also, the vehicle of the petitioner was again came to be requisitioned with effect from 1/8/2020 to 39/2020. Also, it is further projected that the vehicle on it being requisitioned was being driven by a driver who was engaged by the petitioner, and the petitioner was paying the monthly salaries of the driver. Also, in terms of the in connection with the requisition of the petitioner, vehicle of the petitioner, petitioner is an owner of a vehicle bearing registration number ML06A0649 bracket winger bus. In connection with the requisition of the vehicle of the petitioner for the periods noticed herein above, the petitioner had raised a bill for an amount, total bill for an amount of rupees 3, a bill for an amount of rupees 7,85,115. Also, the said bills were submitted in parts, before the Superintendent of Police, Gwalpara. Also, the bills were thereafter forwarded to the office, to the establishment of the Deputy Commissioner Gwalpara for further necessary action. Also, the bills of the petitioner having remained pending, she had instituted the present proceedings. Also, I've heard the learned counsel for the parties and also perused the materials brought on record. Mr. N. Uddin, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the bills of the petition, that the dues receivable by the petitioner being admitted by the respondents, the delay occasioning in release of the same. Release of the amounts involved has caused a severe prejudice to the interest of the petitioner. He submits that the petitioner has been maintaining her family from the earnings of her aforesaid vehicle. Also, per contra, Miss Udas, learned counsel for the respondent, by referring to the affidavit filed by the Senior Superintendent of Police, Gwalpara, in the matter, has submitted that the contention of the petitioner that his vehicle was so requisitioned on for varying periods on 3 different occasions is admitted to by the respondents. Also, it is further submitted by Ms. Udas that the outstanding bills submitted by the petitioner, in connection with the requisition of her vehicle, was forwarded to the establishment of the Deputy Commissioner Gwalpara on 28/9/2021. However, thereafter, the status of the said bills have not been communicated to the Senior Superintendent of Police, to the office of the Senior Superintendent of Police, Gwalpara. I've heard the learned counsel for the parties and perused the materials available on the court. The petitioner in the present proceeding has the petitioner's vehicle was requisitioned by the respondent authorities for varying periods on 3 different occasions.
4 occasions.
4.
Yes.
1, 2, 3, 4.
And last occasion was
4 days. 4 occasions, huh? That is for the period with effect from 26/9/2019 to 29/2/2020, 1/3/2020 to 31/7/2020, 1/8/2020 to 39/2020 and 1/10/2020 to
Well,
12/10/2020. So for the said requisition so made in respect of the vehicle of the petitioner,
Vehicle number kindly.
Huh?
Vehicle number kindly mention.
vehicle I have given in the top.
Yes. Vehicle number is ML
06, the petitioner had raised a bills of rupees 3,16,251 for the period 1/3/2020 to 31/7/2020. Rupees 126,087. So words are liquid for the period 1/8/2020 to 39/2020. Rupees 2325 for the period 1/10/2020 to 12/10/2020. $32452 for the period 26/9/2019 to 26/2/2020. Tarpishwar 316,251 for the period 1/3/2020 to 31/7/2020. Okay, right side. Also, the respondents in their affidavit have not denied the contention raised by the petitioner in his writ petition of the period of requisition of the vehicle and the amount involved in the bills raised by her in this connection. The only stand taken in the affidavit in opposition is to the effect that the bills on being received in the office of the Senior Superintendent of Police, Gwalpara, the same were forwarded to the establishment of the Deputy Commissioner Gwalpara for further processing. Also, in view of the above position, the requisition of the vehicle of the petitioner not being disputed, and further, the bills raised by the petitioner also not being found to have been disputed, this court is of the considered view that the petitioner is eligible for a direction for release of his pending contractual dues in connection with the requisition of his vehicle, that is
ML
vehicle bearing registration number ML-06A-0649 (winger bus). Also, in view of the above discussion, the respondent authorities, more particularly the respondents number 2 and 3, are directed to verify the bills submitted by the petitioner, and thereafter, in the event the same is found to be matching the period of requisition of the vehicle in question of the petitioner by the respondents, from the contemporaneous records maintained in the establishment,
my lord.
the respondents shall release to the petitioner the amount of rupees
My lord, may not be pleased to
7,85,115 and or any other
My-
amount which is found after such verification
my lord.
to be due to
Yes.
the petitioner herein.
Deeply obliged,
Done.
yes, madam.
my lord. As per
Such payment shall be made to the
6
petitioner within a period of 6 months
And-
from the date
6.
of receipt of a certified copy by the respondent number 2 and by the respondent number 3.
Keep possible 4 months.
6
Oh.
6 months, this is
Because
so long,
it-
my lord.
on time will be
Already-
there, my lord, lordship.
Array, Mr.
Would
Uddin
you
will
please
get,
see-
why are you so worried? He'll have a brief, what is there?
My lord, because
4 months, my lord, is.
my client has to do, my lord, pay, otherwise they will
4
face
months is
contempt, my lord.
sufficient, my lord.
Good for you,
Six.
good for him.
No, it's not good for us, my lord. My client will be in difficulty, my lord.
Yeah.
Oh, yeah, like-
Mr. Uddin,
My lord,
in the other cases, just make out a table.
yes,
Period,
yes,
vehicle number, period,
and total amount.
total amount. And each amount, bill each amount, give
Yes.
it to her. 4, 5, 6, 7
Seven.
dispose.
Verify.
Tumhari DB?
Authority is the same.
My-
Verify.
Please to mention the amount, my lord. If your lordship please to mention it, my lord, then again verification will be, my lord.
No, no,
No.
release to that after verification or any other
Yes,
amount found to be due on such
Yes,
verification.
yes. It is.
You have not disputed it. How can I say that that amount is,
Because
that affidavit you have not said para
not
4?
said, my lord, yes,
Then-
because again deputy commissioner will, because this requisition is being, my lord,
It
Deposition
happened,
action.
my lord, the SP on a week back, my lord, called them in the office. And after verify, my lord, he sent the record to file the affidavit, my lord. My client reported me morning that we are called by the
Yes,
SP office.
Mr. Uddin is so powerful. You don't know, he knows everything. Ah,
So, my lord,
Yeah.
and that's,
as SP office, my lord.
Yes.
wherever.
That's why it has to be verified.
Anyway, it's good that the money is due to him. You have taken services. Hey,
I will submit it.
এইটো মোক বনাই দিলে কালি দি দিলে হ'ব বাকীখিনি লিষ্ট দি দিব সেইটো লিষ্টৰ মতে এইটো বহাই দিম
Oblige.
Yes.
Back to the.
Yes.
My lord, first directions of the report, lordships at page 48.
Yes, Mr. Gogoi was given time to make his submissions in the matter.
Lordship,
D. Gogoi, we have R. Gogoi. Okay, no problem.
so here the issue is that the petitioners are holding the personal post, Your Lordship. And Dilip Talukdar specifically stated that there's an ex-cadre post, there
Hmm.
cannot be no scope for promotion, Your Lordship. This matter is completely covered by Dilip Talukdar. Even numerous matters of PHA has come up before this court.
But what about the earlier undertaking given by you?
They're undertaking the
Page 58, para 5, last 6 lines.
However, for the department submits that as when a vacancy arises, the case of a petitioner for promotion shall be considered in terms of the amended rules of 1967. In view of the court opening the order is so complied with.
Yes, you have said that you will consider. Why have
Well,
you said that?
Now
That is a order in a contempt, I suppose.
Yes.
Yes.
the
Have you
since
gone up on appeal?
Lordship,
No.
Now forget that. Forget that. Forget the contempt. Now come to page 52.
this all talks about the rule, the promotion rule, Your Lordship.
You have not gone up on appeal on this.
We have already passed
passed-
speaking order. Neither they have also challenged the speaking order, Your Lordship. A speaking order was already passed.
Where is it?
Page 54.
Okay, now read that speaking order from the second paragraph.
The Honorable High Court by order is so and so directed to take decisions as to applicable to the rule for consideration of the promotion of parties and to inform them by issuing speaking orders. In this regard, the relevant provision of the rule has been duly passed and it is consequent to the amendment of Assam Ministerial District Assessment Rules 1967. The minimum educational qualification for direct recruitment as well as promotion to grade 3 shall be graduation. As such, the same is decided accordingly. As directed the High Court, the Honorable High Court, the concerned engineer are directed to take necessary promotion or incumbent in concerned chief engineer after using all existing government rules and procedures thereof.
Okay, now this is the order which we should read in conjoint with the order of the coordinate bench. Now, how many petitioners are here?
Here the three lordships,
Who are the graduates here?
all are graduate.
All are graduates.
Though they are graduates, but the appointment was
Where? You're in your order, you don't say that.
no, that Dilip Talukdar, the
No,
authorities
Dilip Talukdar was alive at that point of
at the
time.
point that the authorities were not aware of that.
Why?
The-
You were aware. It's a point of law.
It's a point of law. That's how this
But
promoted.
that two orders, this order standing, how can we go beyond this?
But there's an order of the division bench of this court, your lordship. Similar to saying that Dilip Talwar.
You said that it's only because they are not graduates, we are not promoting them.
So after considering them, when they found out that Dilip Talwar exists, they are holding personal posts, ex-cadre posts. There's no scope for promotion.
Ranu, tama ka na, mat. Breaking him up.
There's no scope for promotion for an
Tama ka.
ex-cadre post. So their promotion was not granted. The authorities are bound by this Supreme Court GLT order, your lordship. In fact,
Yes, Mr. Barmia,
Lordship,
they have filed an affidavit here.
affidavit, only a statement,
Have you filed a reply?
reply, I also filed a reply, Lordship.
Para 4, what is the reply?
Yes, Lordship. Page 78, Lordships.
Hmm.
That regard the statements made in paragraph.
You are all regularized in the year 2005.
No, 2003, Lordship.
Where? Who is that
Yes,
2003?
my regular, page 87, first appointment letter, Lordship, we are cadre post. Page number 1, appointment letter, page 82.
Regularization?
And regulation is 87, number 1. First 82, Lordship, under what charge cadre. 82 is the appointment letter, my. Page 82, and next one. Is order number 14 of 1987. In the interest of public service, the following monthly rated workers of this division is temporarily brought under work charge cadre as work charge currency. In the
So
sale
this
of-
is the regularization order of which petitioner?
the regulation order of petition number 187.
One.
1.
No. Petitioner here in this writ petition.
Serial number, yes, last serial number 5.
Sunil, Ranjan
Prasad
Pal.
Kumar Rai.
huh?
Prasad
Photo,
Kumar
sir.
Rai.
Page 87.
Page
at
82 is the
his serial
appointment
number
letter.
78, Prasad
And
Kumar. Rai.
next page,
Next page.
78,
Prasad Kumar Roy.
Prasad Kumar Rai, serial number 78.
And he is petitioner number 1.
Petition number 1.
Hmm.
And petition
Then
number,
where is petitioner number 2?
petition number 2 regulation order is at page 96. It is 2005. And petition number 3 regulation is page 85. He was regularized in 2003 also. Page 90. Page 90, the petition number 3, Lordship, serial number 126.
Petition number 1 is
One is page 96, common order, Lordships.
page 180, page 87.
Page 87 is petition number 1, yes, Lordship.
Relevant is page 90,
Number 2,
80, 80,
regulation
80,
90, yes.
88.
number 2,
88, serial
90,
number
serial number
78.
126.
What is that?
Petition
126?
number 3, Lordship. Serial number 126.
Page,
Page 93,
93, okay.
126.
The
is
letter
petition number
starts at
3.
page 90.
Yes,
Petitioner number 2, page 90.
6.
One minute.
Yes.
This is dated. What is the date of this?
Which one, Lordship? Number 3.
Page 90,
Page 90,
24, 10, 12, 2023.
12, 2029 page, order is the lawsuits.
And your name
It
is that?
dated 24th December 2003, page 95.
Your name is that?
My name is serial number 126. Moinuddin Chaudhary.
This is P3.
This is 3. P3. 126.
And P2?
P2 regulation order is page 96.
Where is this name?
This list not available with me, Lordships, but regulation against, on the basis of this order, Lordship, my service regularized in P2. It was in 2005.
Look at regulation order.
And my name in page 96, Lordship will find serial number 7, Sanjeev Kumar Rai. Page 96, serial number 7, copy to me.
That is P3.
P3,
P2.
P2.
He was a master role
He has a master role.
and other two were book judge.
Lordship. An initial appointment with scale of pay and the work, cadre. Dilip Kumar in respect of those in the post created in 2005 Lordships.
No.
And even earlier order is in favor of us. Lordship.
No. Moinuddin is P2.
Moinuddin is P3.
Yes, anything more?
Since there is a clear directions of the court Lordship to promote, as they also made undertakings before the court, as and when vacancy arise, they will consider promotion.
Okay, done.
Vacancy arose, Lordship.
We'll consider. That much only?
Lordship.
Heard Mr. F.U. Barbia, learned counsel for the petition, also heard Mr. R. Gogoi. Oh, madam, you are appearing for?
Lordship only, respond number 1, Lordship.
Ms. M. Bhattacharjee, learned additional senior government advocate, appears for the respond number 1, while Mr. R. Gogoi,
R.R.
learned
Gogoi,
standing
Lordship.
counsel,
RR.
R. Gogoi, learned standing counsel, public health engineering
Engineering
department, appears for the respondents number 2 to 6. The grievance raised by the petitioners in the present petition is with regard to the non-consideration of the cases of the petitions for promotion to the post of junior assistant available in the establishment where they are presently working. The petitioners submit that the respondents, in clear violation of the directions passed by the coordinate benches of this court in the earlier round of litigation instituted by the petitioners, are continuing to deprive the petitioners of their due promotion to the cadre of junior assistant, in spite of the fact that the petitioners fulfill all the requisite eligibility criteria mandated for being considered for such promotion. Also, the petitioners in the petition have projected that they were initially engaged, projected that the petitioner number 1 and the petitioner number 2 were initially engaged as work charged Classy. All in the office of the respond number 6, na?
No, Lordship. Number
engaged in
3,
the-
respond number 5.
in the establishment of the Executive Engineer, Public Health Engineering Division, Silchar, Division number 2, Kachar. That is the respondent number 6 as work charge Kalasi in the year 1987 and 1992 respectively. The petitioner number 3 is projected to have been engaged as a work charge Kalasi in the establishment of the Executive Engineer, Public Health Engineering, Silchar Division number 1 go to number 2 hobo to number 1. Acha, that is the respondent number 5 on in the year 1988. Also, as the petitioners were continuing in their respective services, comma, the petitioner number 1 was brought to the regular establishment as a classic wide issuance of an office order dated 2011-23. Also, the regularization so affected in respect of the petitioner number 1 was so affected with effect from 1/12/2003. Also, the petitioner number 2 was regularized in his services as a work charge Alasi. With effect from 22/7/2005, wide issuance of a office order dated 6/10/2005. Also, likewise, the petition number 3, wide an office order dated 24/12/2003, was brought over to the regular establishment with effect from 1/12/2003 and engaged as a Khalasi with the regular scale of pay. Also, the petitioners, upon their regularization of their services, were continuing in the regular were thereafter continuing in the regular establishment. Also, vacancies having arisen in the cadre in the post of junior assistant in the establishment wherein the petitioners were so working, they staked STAKED, a claim for being considered for promotion against the said post. The claim of the petitioner for a consideration for promotion to the rank of to the post of junior assistant in the establishment where they were in their respective establishments, having not been considered by the respondent authorities, the petitioners approached this court by way of instituting petitioners along with others approached this court by way of instituting a writ petition, instituting writ petitions being WPC number 5068/2018, by Moinuddin Chaudhary is there here, number 2.
Moinuddin Chaudhary number 3, Lordship.
WPC number
separate writ.
5083.
Separate date petition.
2018. Also, a coordinate bench of this court, on considering the issues arising in the matter, was pleased wide order dated 13/3/2019 to dispose of the writ petition by directing the respondent authorities to take a decision as to the rules which would be applicable for consideration of the promotion of the petitioners, and thereafter to inform the petitioners therein by issuing a speaking order. Also, the respondent authorities having not, the respondent authorities thereafter
Page 54, speaking order.
issued a speaking order dated 28/3/2019 and therein rejected the claim of the petitioner on the ground that they did not possess the minimum requisite educational qualification for promotion to the post of grade 3 in terms of the provisions of the Assam Ministerial District Establishment Service Rules, 1967, bracketed as amended. Also, it is to be noted that it is also projected that the petitioners herein had instituted contempt proceedings with regard to contempt proceedings alleging violation of the directions passed by this court wide the order dated 13/3/2019. The said contempt petitions as instituted by the petitioners and others, came to be disposed of wide an order dated 1/4/2022, wherein the undertaking given by the departmental council to the effect that as and when vacancies would arise in the establishment wherein the petitioners are so engaged, the case of the petitioners for promotion shall be considered in terms with the amended rules of 1967. Also, with regard, we were noticing the said undertaking, the coordinate bench of this court closed wide order dated so and so, 1/4/2020, proceeded to close the contempt petition by requiring the respondent authorities to take into consideration the case of the petitioners for promotion as and when vacancies arise. Also, the petitioners not having been considered for promotion in promotion to the cadre of junior assistant even after the directions noticed herein above passed by the coordinate benches of this court, the petitioners have joined together to institute the present proceedings, praying for the reliefs as noticed herein above. Mr. F.U. Barbhaiya, learned counsel for the petitioner, by reiterating the facts as noticed herein above, has submitted that the respondents having undertaken before this court to consider the case of the petitioners for promotion to the cadre of junior assistant, the non-consideration of the cases of the petitioners, in spite of the fact that they are all qualified for being considered for such promotion and vacancies being available, has caused grave prejudice to the service interest of the petitioners herein. Mr. Barbhaiya has submitted that the petitioners herein cannot be held to be holding personal posts given the manner in which their services were so regularized, and accordingly the decision of this court, of the division bench of this court in the case of Dilip Talukdar and others versus State of Assam and others, reported in 2017, (2) GLT 135, would have no application to the cases of the petitioner, and their cases have to be considered on their respective merits by recording the qualification as possessed by them. Also, accordingly, in view of in the above premises, Mr. Barbhaiya submits that vacancies being available in the establishment of the respondent number 5 and the respondent number 6, against which the cases of the petitioners can be considered, a direction is called upon to be issued by this court upon the respondent authorities to expeditiously consider the cases of the petitioners for such promotion against the vacant posts of junior assistant available in the above 2 establishments. Per contra, Ms. M. Bachaji, learned counsel for the petition, submits that the promotion claimed by the petitioners would have to be considered by the Public Health Engineering Department in accordance with the provisions of the Assam Ministerial Establishment Service Rules 1967 as amended. Also, Mr. R.R. Gogoi, learned standing counsel, PH, Public Health Engineering Department, at the outset submits that the petitioners herein were so regularized against in their regularized in their respective services against personal posts created for the purpose in respect of each one of them. He submits that the personal posts as created for the purpose of regularization of the petitioners and others were to continue to be subsisting till the same is vacated by the petitioners in any manner. He submits that the petitioners, having been regularized in their respective services, facing respective services against personal posts created for the purpose, comma, the post as created would not add to the cadre strength of the post of to the cadre strength of the grade 4 post as available in the divisions wherein the petitioners are working, and accordingly they cannot be treated, they cannot be deemed to be incumbents holding posts in the feeder cadre for the purpose of promotion to the post of junior assistant. He relies upon the decision of this court of this honorable court in the case of Dilip Talukdar and others, Supra, and submits that in terms of the prescription made therein, he further submits that in terms of the said decision, the petitioners herein are not entitled to be considered for promotion to the next higher grade of junior assistant.
I've submitted another judgment, Your Lordship. One Mamoni Pahari were discussed thoroughly, Your Lordship.
Huh?
At para 4.7, this Mamoni Pahari, a review was filed regarding this. Para 4.7, 10, 11, and 12.
He has also placed reliance on a decision of this court, of a coordinate bench of this court in the case of Mamoni Pahadi and another versus State of Assam and others, bracket, box, review petition number 147, 2022, order dated 29/3/2023.
I will rely on
With regard to the undertaking as given by the learned departmental council and recorded in the order dated 1/4/2022, passed by the coordinate bench of this court in contempt case number 136/2020 and 137/2020, Mr. Gogoi submits that the same would not in any manner confer upon the petitioners a right to claim for having their cases considered for promotion to the next higher cadre of junior assistants, inasmuch as the said submission undertaking was so given by the departmental council as well as by the department, being ignorant of the decision of this court, of the division bench of this court in the case of Dilip Talukdar. He submits that the decision of this court in the case of Dilip Talukdar shall hold holding the field as on date, and it would be the prescription made therein that would be applicable in the matter and not the undertaking given by the departmental council. Anything more? Also, in the above premises, Mr. Gogoi submits that the present writ petition would mandate, submits that the claim of the petitioners herein for being promoted to the next higher cadre of junior assistant, given the this condition of the petitioners herein would not mandate an acceptance of this court. Also, I've heard the learned counsel for the party and perused the materials available on record. It is not disputed that the petitioners herein were engaged, prior to 1/4/1993 as work charged and/or as muster roll workers. So, while the petitioner number 1 and 2 were so engaged in the establishment of the respondent number 6, the petitioner number 3 was so engaged in the establishment of the respondent number 5. The petitioners had had rendered continuous service since the date of their initial engagement as a work charge and/or master role employee. Also, in terms of the policy of the state for regularization,
Employee. Work charge fixed pay employee. Which scale of pay?
work charge is scale of
Which scale of pay?
scale of pay, always. Please, sir. In terms of the policy of the state of the government of Assam for regularization of the services of work charge, muster roll, casual employees engaged prior to 1/4/1993, the cases of the petitioners were taken up for consideration for such a regularization of their services. Also, the petition number 1 herein. Also, the services of the petition number 1 herein was regularized,
Page 87.
came to be regularized with effect from 1/12/2003. As Khalasi, grade 4, wide issuance of a office order dated 2011-2003. So, it is this court would notice that in the order dated 2011-2003, a prescription was made to the effect that the post against which the services of the petitioner and others involved were regularized, were created temporarily and in the name of each of the persons involved, including the petitioner herein, which would simultaneously be abolished with the cessation of service of the petitioner and others involved. Also, likewise, the services of the petitioner number 2 was regularized wide issuance of an order dated 6/10/2005. Accordingly, the petitioner number 1 services were admittedly regularized against a personal post created for him. Created for him. Full stop. Next para. The services of the petitioner number 2 was regularized wide issuance of an order dated 6/10/2005 with effect from 22/7/2005. Full stop. It is not in dispute. The Learned Council for the parties have not disputed that the regularization of the services of the petitioner number 2 was also against a post created for the purpose. Created in his name for the purpose, and full stop, that is against, that is against a personal post. The respondents in their affidavit have made categorical statements to the said effect. Full stop. The next part. The services of the petitioner number 2, petition number 3 was regularized again with effect from 1/12/2003 in pursuance of the approval of the government as finding reflection in the office order dated 2011-2003 issued towards a regularization of the services of the petitioner number 1 hearing. Accordingly, The regularization of the services of the petitioner number 3 is also to be construed to have been so effected against a personal post created for the purpose in his name. Also, the posts against which the petitioners herein were so regularized, being personal posts, would cease to have effect on cessation of the services of the petitioners in any manner known to law. The said posts admittedly were not so created in addition to the posts already forming the cadre strength of the grade 4 service of the division wherein the petitioners are so engaged. Also, a division bench of this court,
Paragraph 456. Division bench of judgment lordships, in those who are regularized in 2005.
no, here that is why your order says personal post. What more is
Orders-
required?
Yes, my orders reflects lordship personnel, but
Hmm.
division bench says those who are regularized in 2005 and government has.
The issue as arising in the present proceeding had arisen for consideration before a division bench of this court in the case of Dilip Talukdar, bracket Supra. The division bench of this court drew the following conclusion in the matter. A judgment clause WPC 5579/2023. Para page 11 of the A to A. Para 7 to the So, applying the decision of the division bench of this court in the case of Dilip Talukdar to the facts of the present case, this court finds that the services of the petitioners herein, having been so regularized by creation of posts personal to them, the same being not in addition to the cadre strength of the grade 4 posts of the division wherein the petitioners were so engaged, the petitioners cannot be deemed to be in the feeder cadre or being considered for promotion to the next higher grades of the service, including the post of junior assistant, which is a grade 3 post. Also, having drawn the above conclusion, this court would now examine the contention raised by the learned counsel for the petitioner with regard to the undertaking given by the learned departmental counsel before a coordinate bench of this court in the proceedings of contempt case number 136/2020 and 137/2020. The said undertaking is recorded in the order dated 1/4/2022 passed in the above noted contempt petition, and the same being relevant is extracted herein below. A to A, page 58. Murray, however. A perusal of the said undertaking would go to reveal that what was contended was that the petitioner's case would be liable for consideration in terms of the amended provisions of the rules of 1967. Also, even if the said undertaking given by the departmental council is taken on its face value, comma, the division bench in the case of Dilip Talukdar having already laid down that persons holding personal that work charge oblique muster roll workers regularized in their services against personal post would not be eligible for being considered for promotion to the next higher grades to the post figuring in the grade 3 of the service, comma, they said undertaking notwithstanding, this court would not be in a position to issue a direction upon the respondent authorities to consider the case of the petitioners herein in violation of the direction of the law laid down by the division bench of this court in the case of Dilip Talukdar bracketed Supra. So, in view of the above discussion, this court is of the considered view that the claim of the petitioners for being considered for promotion to the post figuring in the grade 3 of the service would not mandate an acceptance inasmuch as the petitioners by virtue of the post held by them on their regularization of their services, comma, cannot be held to be an incumbent in the feeder cadre or being considered for such promotion. So, accordingly, this court is of the considered view that the present writ petition is devoid of any merit and consequently the same stands dismissed. However, there would be no order as to cause. Sorry, Mr. Barbian.
Lordships, because Dilip Talukdar,
Huh?
because of Dilip Talukdar, Lordships.
Can't help it. It's binding on me.
Dilip Talukdar